Hello everyone and welcome to Tax Space. Today in this particular discussion, we are going to see the landmark judgment passed by Madras High Court in case of DY Beathel Enterprises. Now, before understanding the effect of this particular landmark judgment, we have to first understand the existing scenario under GST, and then we shall analyze and understand the impact of this particular judgment on the existing GST scenario. Okay, assume that there is a seller being DY Beathel Enterprises, that goods were sold by Charles and his wife Shanti. Okay, yes, when a seller sells goods, supplies goods to a buyer, in that case, along with the goods, an invoice is supplied by the seller to the buyer. Invoice comprises of value of goods as well as GST charged on those particular goods, and then the buyer has to make a payment of the value of goods as well as GST to the particular seller. In this case, what does the seller do? Seller keeps the value of goods in his own pocket, and then he makes the payment of GST to the particular GST department. The amount of GST paid by the buyer to the seller is claimed as GST credit by the buyer. Okay, now this is the existing scenario under GST. Okay, now assume that if seller does not make the payment of GST to the GST department, in that case, till today, before the landmark judgment passed by Madras High Court, GST department used to approach the buyer. Okay, used to approach the buyer for reversal of ITC in order to recover the GST which is not paid by the seller. You hear me right? You hear me right? मतलब buyer ने value of goods का payment भी किया है seller को, GST का पेमेंट भी किया है सेलर को, पेमेंट किया है प्रॉपर बैंकिंग चैनल से, और सेलर ने कलेक्ट किया हुआ जीएसटी गवर्नमेंट को पे करने की जगह पे अपने पॉकेट में रख दिया. इसकी रिस्पॉन्सिबिलिटी वाज बोर्न बाय द बायर बाय रिवर्सल ऑफ ITC. Okay, now what happened in this particular case is the buyer approached the Madras High Court, and then the contention of the buyer was कि अगर हमने वैल्यू ऑफ गुड्स पे किया है, जीएसटी पे किया है, फिर द जीएसटी डिपार्टमेंट शुड फर्स्ट अप्रोच द सेलर, एंड ऑन नॉन पेमेंट ऑफ जीएसटी बाय द सेलर ऑल द नेसेसरी स्टेप्स बी टेकन बाय द जीएसटी डिपार्टमेंट, बट द seller should be approached first, and then recovery of GST should be initiated against the buyer. Madras High Court supported this particular contention, and then the judgment passed by Madras High Court was that if seller does not pay the GST collected by it to the GST department, the GST department has to first approach the seller, take all necessary steps, take all necessary actions in order to recover the GST from the seller. And not only this, it also has to maintain a proof of all the efforts taken by the GST department for recovery of GST from the seller. अब मुझे बताइए, क्या इसका मतलब है कि क्या जीएसटी डिपार्टमेंट बायर के पास कभी जा ही नहीं सकती फॉर रिकवरिंग जीएसटी? नो. Understand. GST department has to first go to the seller. Under exceptional circumstances, if the GST department fails to recover GST from the seller, only and only then the GST department can approach the buyer and can collect the GST by way of reversal of ITC already claimed by the buyer. So this landmark judgment has provided a relief to the buyers in all cases and provided them a sense of security and confidence in this GST regime. Thank you so much. To stay updated and to know the latest amendments, please subscribe to our channel and press the bell icon in order to get all the latest updates. Thank you very much.